Good morning, everyone. Appreciate everyone joining us this morning. And today's webinar is going to focus on the OSHA COVID-19 ETS mandate, what policies your business needs to comply. I am Scott Parson. I'm the CEO of Staker Parson Materials and Construction, and I'm a co-chair along with Mikkel Moore of the Roadmap to Prosperity Coalition. You might notice that we've changed recovery to prosperity because we're hoping to move well beyond recovery to a prospering economy. Our coalition is a business-led coalition focused on implementing and promoting our economic recovery. On November 5th, 2021, OSHA issued the COVID-19 Vaccination and Testing Emergency Temporary Standard, shortened to ETS, and this applies to all companies with over 100 employees. This rule requires businesses to develop a written COVID-19 policy, including setting up an assessment process for their employees, creating guidelines on receiving proof of vaccination, and establishing a record-keeping system containing this information. Additionally, a key factor of the policy is, as it's currently written, it will require that employees be fully vaccinated against COVID-19 or that they submit and provide evidence of weekly testing. As such, many businesses are left wondering where to begin and what we need to do to comply with this new ETS. To help us better understand this, we've partnered with SixFifty Technologies to do just that, and we really appreciate their team joining us today. I'd like to introduce Ryan Parker, and we'll go ahead and turn it over to you, Ryan. This will be an informative session. We invite questions and have left time both throughout and at the end to address questions. So Ryan, we'll turn it over to you.
Thank you so much, Scott. We're excited to be here, and we want to thank also the Chamber for inviting us to put on this webinar on what is a very interesting and dynamic topic. There's a lot going on with this emergency temporary standard, and so we're going to focus on some of the details of the standard and how it could affect Utah businesses, and we'll try to make that specific. I want to start by introducing my co-presenters today. We'll start with Marie Colbeth, who is a Vice President of Legal Product and the General Counsel at SixFifty. Marie is an excellent attorney. She went to a top law school. She clerked on the Fifth Circuit Court of Appeals, and you'll hear more about the Fifth Circuit later in our presentation, and then worked at BYU Law School before we were able to recruit her to SixFifty. And she does an incredible job helping us develop products, but also serving as our general counsel at SixFifty and figuring out how to implement these laws for our business. And so she really brings a very practical approach to looking at the ETS. We also have with us Adrian Jack. Adrian also went to an excellent law school, practiced at a top law firm in Washington, D.C. She then moved back to Utah and worked at Curtin McConkie, one of the best firms in the state, before joining us at SixFifty. And then we have Adam Wright. Adam went to what I think is the best law school, the University of Michigan, before clerking for 2 federal judges in North Carolina. Adam also worked at Parsons Bailey, one of the best, another excellent law firm here in the state, and has now joined us at SixFifty. And I'm Ryan Parker. I'm the Chief Legal Product Officer at SixFifty. As I said earlier, I attended the University of Utah and then went to the University of Michigan Law School before clerking for district court judges in Michigan, district court judge in Michigan, and the Third Circuit Court of Appeals. I then worked for the Department of Justice for about a decade before moving into the intelligence community and then coming to SixFifty. So the 4 of us have spent a lot of time looking at the ETS, because at SixFifty, what we do is we try to make the law more accessible for businesses and individuals. And part of what we've done to help make the law more accessible for businesses is we've created a return to work tool set that helps businesses figure out how to bring their employees back to work sites and how to manage all of the shifting requirements that have come with the pandemic. And as part of that, we've created a new tool set to help businesses with the federal emergency temporary standard that Scott introduced earlier. And so we've spent a lot of time thinking about the ETS and how it affects businesses, and we're helping businesses across the nation as they decide what steps they're going to take there. And so we're going to take some of the knowledge that we've acquired in building these different tools, and we'll kind of lay out for you some thoughts about the ETS. Before we dive in, I just wanted to bring your attention to the Q&A button at the bottom. We're happy to answer any questions that we can. We'd appreciate if you put it in the Q&A so that we can try to answer that many of them as we go. It's a lot easier than if you put it in the chat. We'll also save time at the end of the webinar for questions. So we'd love to make this interactive. Please don't hesitate to put your questions in the Q&A. The one question that we get at every webinar is, are you going to share the slides, or can we get a recording of the webinar? And the answer to both those questions is yes. We're planning to share the slides that will come through the chamber. And I believe that the webinar is being recorded. And so that's something you don't need to worry about. And with that, we'll get ready to launch. Before we dive into the ETS, I will just mention, and for those of you that have joined in, I think you're already aware of this fact, but issues around vaccination and specifically the ETS have become highly politicized, and we will try to just kind of give you the details and the facts. We're not going to editorialize on our political opinions about these things, and we'd ask you to maybe refrain from doing that in the questions as well, so that we can kind of hit on the meat of the subject. And with that, I'll go right into our agenda for today. So we will be, there we go. We'll be starting with the introduction, which is now almost over. We'll then move right into litigation and legal challenges. That's my section. I'm excited for that one because there's a lot that's going on in the litigation area, including some very recent developments. Marie's then going to talk to us about Utah issues, and then we'll move to employee headcount, written plans, which Scott mentioned earlier, the vaccine and test mandate, which has kind of been the big issue that we've had, and then we'll talk about other requirements. I know I saw a comment hop up that we're having some problems with the slides. Let's see if we can move to the next slide and see if that'll be better. So as we move through these different topics, feel free to put any questions that you may have into the Q&A. The first thing we're going to do is just give you a little background on the ETS. Scott did an excellent job actually on that. So what is an ETS? The federal ETS is an emergency temporary standard issued by the federal OSHA, and it was issued on November 5th, 2021. I have a link in the slides to the Federal Register. I'm going to warn you in advance, if you want to read the ETS, it's 154 pages, and it's in that great print that they use for the Federal Register that has 3 single-space columns. So it's very long. There are lots of details, and we spent a lot of time going through those details, and we'll explain some of them to you. The really big ticket item in the ETS is that under the ETS, employers with at least 100 employees must adopt a vaccination policy that requires employees to be fully vaccinated or submit to at least weekly testing. And we'll talk more about that requirement coming up. So let's jump right into the legal challenges, because this has been a really kind of an incredible area. President Biden announced that these ETS would be issued in October, and so there was plenty of time for litigants to prepare for the issuance of the ETS. They were ultimately issued on November 5th, and within 10 days, 34 different lawsuits were filed in all 12 regional circuit court of appeals. Pretty incredible. 26 states, including Utah, have joined in on those lawsuits. And so the lawsuits are by a combination of states and private employers, and they've been brought in every single circuit in the country. We saw some very early action by the Fifth Circuit, which is generally regarded as the most conservative circuit in the country. It's also where our presenter, Marie Colbeth, clerked down in Louisiana. And the Fifth Circuit took the motion for a preliminary injunction, looked at it, and granted a stay of the ETS pending review. And what a stay means is that OSHA could not, while the stay was in place, start to enforce the ETS. The Fifth Circuit then followed that up on November 12th. It issued a lengthy, a 22-page opinion reaffirming its initial stay. Any law nerds out there like me, I actually put a link to the opinion if you want to look at it. It actually has some interesting, colorful language explaining why the Fifth Circuit stayed the application of the ETS. So we often get questions, what does a stay mean? What does it mean when a court like the Fifth Circuit steps in and stays something? It means that in this case, OSHA cannot start enforcing the ETS. And we'll cover this a little farther along as we get into the details, but there are two deadlines in the ETS that are quickly approaching. One is that by December 4th, companies are supposed to have a written policy that sets forth how they're going to handle vaccinations. And then by January 4th, they have to be enforcing that policy. And I think with this stay in place, those deadlines are likely to be pushed, although we really don't know what's going to happen with the Fifth Circuit's stay. I'll also mention, for those who are kind of wondering, one interesting part of the ETS is that it provides for review by the Circuit Courts of Appeals. So the challenges did not go through a district court first, which is usually the path that federal litigation takes. You go to a federal district court, which is the trial court, and then it moves up to the circuit court. The OSHA Act provides for review directly in the circuit court, and that's why all these 34 suits were filed in the different circuits. So after the Fifth Circuit issued its stay, the question is, what's next? And it puts, I think, our legal system in an interesting situation, because there were so many different suits that were brought in different circuits. So what if the Fifth Circuit decided that the ETS needed to be stayed, but the Ninth Circuit said it didn't need to be stayed? What would we do there if we had a conflict? And the way that we resolve those conflicts in these types of cases, one of the ways is through something called the Panel on Multidistrict Litigation. And so when you have a number of different suits that are filed involving similar parties and raising the same issues, they can be consolidated. And what happened here is the Justice Department went to the Panel on Multidistrict Litigation and said, we've got these 34 suits filed in all 12 of these jurisdictions, and we need to consolidate them into one case heard by one court. And so the Panel for Multidistrict Litigation held what some news outlets have called a Powerball-like lottery. And actually, when I heard about like the details of the lottery, it didn't sound all that much like Powerball to me, because it was not very technologically advanced. In fact, apparently they used a wooden bucket and 12 ping pong balls. I kind of wonder whether someone took a Sharpie and like wrote the numbers for each circuit on those ping pong balls, and then someone reached in there and pulled out the ping pong ball, and the lottery winner was the Sixth Circuit Court of Appeals. I'm sure there was a lot of celebration there in the Sixth Circuit as they were tasked with handling these 34 consolidated cases. And so what that means is that a panel of 3 judges from the Sixth Circuit Court of Appeals will ultimately hear these consolidated cases. And for those of you that are following along at home, the Sixth Circuit is in the middle of the country. It covers courts in Michigan, Ohio, Tennessee, and Kentucky. And interestingly, the Fifth Circuit is generally considered to be one of the more conservative circuits. I would say the Fifth Circuit is typically the very most conservative, and maybe the Sixth Circuit right behind it. There are 16 judges on the Sixth Circuit. 11 of them were appointed by Republican presidents. So actually 6 were appointed by President Trump, 5 were appointed by President George W. Bush, and a total of 5 were appointed by Presidents Bill Clinton and Barack Obama. So it's a circuit that tends to lean a little conservative and certainly has more Republican appointed judges than some of the other circuits. And so that's an interesting development. I don't think, however, that means that the ETS will necessarily be struck down. I think it's very difficult to know what's going to happen. And why don't we move on to the next slide here? There are factors that cut in both ways, I think, here. We have a more conservative circuit. We also have the fact that in its 50-year history, OSHA has issued just 10 ETS. This is an emergency procedure that they don't use very often. Of those 10, 6 were challenged in court and only 1 has survived. So the odds for the ETS surviving based on past history are not very high. That being said, most of those challenges happened in the 70s, the most recent happening in the early 80s, and they did not involve things that really resembled in any way COVID-19, a pandemic that has really kind of spread across the country and had such widespread effect. And so I think it's difficult to read too much into the past history of the ETS, but if you want to look at that as a factor, you know, OSHA has not had a lot of success having its ETS upheld. On the other hand, the Supreme Court has already rejected 3 different challenges to vaccination mandates in New York, Indiana, and Maine. And so maybe, you know, I think it's very likely that after the Sixth Circuit makes its decision, that decision, regardless of what it is, will be appealed to the Supreme Court. And the Supreme Court has already shown at least that it is open to upholding vaccine mandates. And I will also add that many of those state mandates did not include the testing option that is available under the ETS. And that may be an important legal point, that they're actually not requiring people to be vaccinated. They're only requiring them to be vaccinated or frequently tested. So I think it's really up in the air, very difficult to tell which way things will go. I think you have people that are trying to read the tea leaves with which circuit is selected or other things. Ultimately, I think this will be decided by the Supreme Court, and I think it could go either way. So where does that leave businesses? Obviously, businesses don't love uncertainty, and that's what we're faced with here with the federal ETS. But I think that we're seeing a couple of trends. We've seen a number of businesses that have decided to voluntarily adopt the federal ETS in a way that they think makes sense to them as a business. And then if the ETS is upheld, they're already complying. We've seen some other businesses that are taking a wait and see approach. We recommend at least that businesses familiarize themselves with the ETS and that they prepare to implement them. Because if the ETS are ultimately upheld, I think it's very likely that there will not be a lot of time for businesses to comply. I think that the deadlines that we'll talk about a little later, the December 6th deadline for a policy and the January 4th deadline to implement that policy are likely to be pushed, but businesses may not have a significant amount of time to create a policy and implement it if the ETS are ultimately upheld. I would say just one other thing before I turn it over to Marie. Further complicating this for businesses will be what states do. And Utah very recently took some action on this front, and Marie's going to touch on that because, and I think we had a question on this as well. You know, what states decide to do while the ETS are being litigated could also affect how businesses decide to address this issue of vaccination. So that was a lot to cover on litigation. This is kind of an exciting for litigators. This is a really exciting case to see it go through the panel of multi-district litigation and see how this is playing out. But this litigation really does have a very direct effect on businesses. And so we'll be watching it closely. And with that, I will turn the time over to Marie to discuss Utah specific concerns about the ETS and the litigation.
Thanks, Ryan. And I do have to say, the law nerd in me finds this all really exciting. The general counsel in me, who's helping run a Utah business, is like not excited at all. So with that, I'm going to start off by talking a little bit about Utah's state OSHA plan and moving into, as somebody has already been asking about in the chat, Utah's recent legislation. So if you do have questions, if you could put them in the Q&A, I anticipate we'll see more questions here because we're getting into some of the practical aspects of what's happening in Utah. So first of all, just for those who may not be aware, we've been talking about the federal OSHA rule, the ETS, but Utah is one of the 22 jurisdictions that does have its own state OSHA plan. Which means we have a plan that's been approved by Fed OSHA. So Utah oversees and administers and enforces it. But there are some requirements that Utah has to meet in order to maintain its own state OSHA plan. So this is sort of a map in case you're a business that has offices and employees in multiple states. The dark purple states have state OSHA plans, and the light gray states are Fed OSHA only, and the dark gray states have a state OSHA plan for public employees, but Fed OSHA for private employees. So that's just to sort of orient you, but we're going to focus on Utah right now. So with that, Utah, as well as 2 other states, have their state OSHA plans under fire right now. So a little bit about why we have the state plan at all, and then why ours are under fire. So state plans, unlike Fed OSHA, apply to not only private sector employees, but also public sector employees. So we have sort of a laboratory of states approach. So those states like Utah that have their own plan can try new things. California is known for having sort of like the most active OSHA, trying out regulation in spaces that aren't required by Fed OSHA. They do in fact have their own COVID ETS that's been in place for quite a while now. Utah is kind of highlighted in the news right now because we didn't issue an ETS for health workers after federal requirements mandated that in the summer, and I'm going to spend some time on that in a second. Other states like Virginia has their own, and they were the first state to implement a permanent COVID standard. So not an emergency one, but a permanent one. So we have this sort of state by state laboratory approach where we're trying out different things in different states. The nice thing about this for us is that federal OSHA bears 50% of the costs, but the state has more control. But there's drawbacks to that too. And one of those drawbacks is how much control do we have and how much control do we not have? And that is the space that we're in right now with Utah's OSHA and some problems that we're having between Utah and federal OSHA. So if we go on to the next slide, Utah and Arizona and South Carolina all received letters from federal OSHA last month telling us that our state plans were at risk of losing their approval. Why is that? Well, when there's an ETS that goes into effect at the federal level, for that to have an impact on a state OSHA, the state has 15 days to respond to OSHA and say, hey, we see the new rule. We have plans to make our OSHA protect our employees as well as or even better than federal OSHA. So at 15 days, you have to notify them, what are we going to do? And then at 30 days, the state is required to issue state OSHA requirements that are at least as protective as the federal requirements. So back in the summer, we had sort of a preview of what's happening now when federal OSHA issued its June ETS, which applied specifically to healthcare workers. So some of you may remember this. When it did that, Utah OSHA, UOSH, it did not issue requirements. So at 15 days, it didn't send OSHA a letter that said, this is how we're going to comply. And at 30 days, it didn't issue state requirements. In fact, there's actually some public statements that were made in Utah saying that we didn't plan to comply and that we would just sort of wait out the clock for the ETS to expire. So because of that, federal OSHA responded and they said, well, we're going to revoke your state OSHA status if you don't comply. And they sent that letter on October 19th. And now if federal OSHA chooses to, the next step that they could take is to actually file an official notice in the Federal Register that they intend to revoke the Fed OSHA status of the 3 states. So that's like a pending ongoing thing with Utah OSHA that was sort of seen as a precursor to what's happening now, because at the time when Utah said, we're not going to do this, we don't plan to comply, we have these issues with the requirements, it was already known that the new ETS from OSHA was going to come out that applied to all employers with 100 or more employees. And it was anticipated that Utah would not want to comply with that either. So some people are looking at this as sort of like a microcosm into what's about to happen with this federal standard ETS once it comes out of the stay that Ryan talked about, whereas right now, nothing's actually happening while we wait to see what the courts say. But Utah is still in this ongoing situation with the previous ETS, which I think a lot of businesses may be less aware of, because if they're not in the healthcare space, it wasn't directly affecting them. But if Utah were to lose its state OSHA status, that would affect all of us. So an important thing to be aware of just in terms of how things are playing out. there's a whole procedure that OSHA would have to go to revoke Utah's state plan status that would take a lot of time and honestly could not be accomplished before the ETS did expire. But again, like it is a fairly important thing to be aware of, and to just sort of keep in mind that while OSHA has never revoked a state status, Hawaii voluntarily gave theirs up at one point because they couldn't meet the requirements and they got it back. They have threatened it before, one of the most recent times being against Arizona for some failures to comply with requirements for safety in the construction industry. And after the threat, Arizona became compliant, and so they kept their state plan status. So there is a procedure in place. If you want to read more about it, there's a link to a really, really long section of the Federal Register about how that would happen. But that's sort of happening in the background while we are focused on what's happening with this mandate regarding employers of 100 or more employees. And so because of these ongoing issues with OSHA, as well as other things happening in the state, there was a special legislative session that some of you might have been following, which led to some new legislation in Utah that was just signed by Governor Cox on Monday. So if we could go to the next slide. This is maybe what most people on the call today are interested in right now, because while we're waiting to know what we have to do to comply with OSHA, there's some things we're going to need to do here in Utah. So sorry, this is just summarizing all the issues we have with OSHA right now. Utah's involved, I forgot to cover this. Utah's involved in 3 different lawsuits. The first one was filed in October against the executive order mandating vaccination for federal contractors. The second one is the one that Ryan went into detail on, the federal ETS. That could affect 2/3 of our workforce here in Utah, and it could be also construed the fact that we filed that lawsuit as sort of a response to the letter from OSHA. We're not planning to comply with any of these, according to the lawsuits at least. And then also a third one that was just filed against the vaccination requirement for healthcare workers in Medicare and Medicaid facilities. So Utah is involved in all of that ongoing litigation. But for the moment, the only one that is stayed is the one regarding large employers. So if you're dealing with federal contractors as employees, if you are a Medicare or Medicaid covered facility, those rules are in place. They haven't been stayed. You need to be following them or preparing for them. And that is what brings us. So that's the litigation posture of Utah. So this brings us to practically what does that mean for us? And for now, it means we need to pay a lot of attention to the law that just passed on Monday. So the new Utah amendment basically requires employers that do have vaccination mandates to provide exemptions for 3 categories of employees. Those are employees with health reasons to not be vaccinated, who have a sincerely held religious belief against the vaccination, or, and this is new, a sincerely held personal belief. The personal belief is a new term. It's not defined in the statute that was signed, and it's not defined anywhere else in law. It's not what we call a legal term of art, where it's oh, we know what that means. So as an employer, I don't know what that means. So we had a whole conversation before this webinar about, what's a sincerely held personal belief? Do any of us hold insincere personal beliefs? It's really hard to know what exactly that exemption requires of a business. In addition, this rule prohibits adverse action against any unvaccinated employees or applicants for employment. And you have to also require employers to pay for any testing requirements. So if you do have a vaccination requirement, you say you can be vaccinated or you can be tested, you as the employer would need to pay for that testing. And then finally, it prohibits employers from keeping copies of vaccination records. And Adam's going to talk about both of those in a little more detail later in terms of what the ETS requires. So bearing in mind that under this Utah rule, those are the requirements. So first of all, what is adverse action? So you can't take an adverse action against an employee or a potential employee. Adverse action would include, demotion, reducing somebody's hours, terminating the employee because they were not vaccinated. What it wouldn't include is reassignment. So maybe you have an area of your business that is particularly sensitive to potential outbreak. Maybe you're dealing with patients. Maybe it could be a lot of different reasons. And so you say, we're going to reassign that employee to another non-sensitive area. That would be fine. Alternatively, if reassignment isn't practical, but you can't have them in their previous position, then termination could be allowed. But that's it's a really dicey space, right? At that stage, you for sure want to consult with legal counsel, I would say. And then on the record keeping side, well, if you can't keep a vaccination record, what can you do? You can collect records by self-attestation. So you just ask your employees if they're vaccinated and you record what they say. You could also review their actual vaccination record. So have them bring in their card, a picture of their card, or something from their doctor. You review it and you record it, but you don't keep the actual records themselves. If you previously have collected vaccination records, so if you've had a mandatory policy, you've been collecting copies of people's cards, you could claim that you have a previously established business practice. So you could keep those potentially. But what you shouldn't do is start collecting copies of cards now or on an ongoing basis after this new law has passed. So if you're in the practice of saying like, hey, we're hiring a new employee, let's get a copy of their vaccination card, don't get a copy. Just look at it and record what you saw. So those are sort of some of the do's and don'ts under this new Utah law. And then, from a practical perspective, the federal OSHA rule is still being litigated. It's under a stay right now. So you do need to plan for what your business will do if and when that stay is lifted. For now, the rule that definitely applies is the Utah rule. And in the future, we're going to see some more litigation. I anticipate that we will see some controversy over what a sincerely held religious belief is and whether that exception is so large that really there's no rule left potentially. That's one of the concerns that's been brought up about this rule with that new exception that's not defined. And then there's the issue of, if the stay is lifted on the ETS and it goes forward and the ETS is upheld, then you have federal preemption where the Utah statute is preempted by the federal rule when it cuts against the federal protections. And then, of course, as I talked about in a little bit of detail, the potential loss of our state OSHA plan is still out there in the universe as a possibility. So practically speaking, a lot of employers will probably choose to continue with remote procedures so that they don't have to deal with that question of, vaccination if they want to follow the ETS, but they're concerned, or they are not sure what they want to do because they're waiting for that ETS and they don't want to implement a policy now that's compliant with Utah that might not fulfill the ETS requirements in a month. A lot of employers are kind of taking a wait and see approach for a minute to see where this shakes out with that stay that's been issued in the federal case. So, continuing remote procedures if possible might be a good solution for some employers. But there's a lot of movement here, and we'll continue to keep people updated as much as we can. But I would say my approach to this is be compliant with Utah now, but you do still need to plan for how you could do that while being compliant with the OSHA ETS, which is what Adam and Adrian will now talk about in a lot more depth.
Thanks, Marie. Marie, did you want to cover the employee headcount?
Oh, yes, I can. Sorry about that. Just really quickly. So when Adam is talking to you about what the ETS requires, if you're not sure if it applies to you, it's the question of whether your company has 100 employees and whether those, and it doesn't matter if they're all at the same work site or not, they can be in different states, but 100 total headcount. If you had fewer than 100 employees, but you hired 10 or 15 people since the ETS was passed and now you're at 100, then it applies to you. Even if you have 100 employees and then you let a few people go and you drop below 100, it still applies to you because you were above 100. And so that's how you know that the rule applies to you. But just because the rule applies to you doesn't mean it applies to all of your employees. So if you have some fully remote employees they do not have to be vaccinated or tested weekly because they're fully remote. So just keep that in mind. And then in terms of counting your employees, the basic rule is they all count. Seasonal workers, part-time workers, remote employees, people who work outdoors, minors. Who doesn't count are if you have staffing agency employees that are coming to your work site, but they're employed by the staffing agency will count them, you will not. And similarly, if you have independent contractors, you do not count them under your employee headcount. They're counted either by that contracting company, or if they're individuals, they're on their own and this won't apply to them. So that is sort of the takeaway for knowing whether what Adam's about to tell you about applies to your company.
Thanks, Marie. So Marie did a great job of covering the new Utah legislation. And now we're going to shift gears and talk about what the federal ETS requires. So if your business is covered under the ETS, if you meet that 100 employee headcount that Marie just talked about, any ETS survives the legal challenges, these are the requirements that your business will need to meet. So let's first talk about the written policy requirement under the ETS. So the ETS essentially gives companies two options for the policy. One, you can have a written mandatory vaccination policy, or you can have a policy that gives your employees a choice to either be fully vaccinated or to provide proof of regular testing. And your policy could be a mix of the two. So maybe you're a company that has a set of employees that work directly with customers, and then another set of employees that hardly interact with anyone and they're in a back office or something like that. You could have a mandatory vaccination policy for the first set and then give the second set the option, the testing option. So it can be a mix of the two. You could have a partial mandatory vaccination policy. Let's talk about what some of these terms mean. So what does regular testing mean? It typically means every 7 days, but when we talk in more detail about the testing requirement, we'll get into some nuances there. And then what does fully vaccinated mean under the ETS? It means that an employee is fully vaccinated 2 weeks after completing the primary vaccination. So typically 2 doses if it's Pfizer or Moderna, 1 dose if it's Johnson & Johnson. Acceptable vaccines include those that are approved or authorized for emergency use by the FDA, or those that are listed for emergency use by the WHO. And in some limited circumstances, vaccines that are administered as part of a clinical trial in the US. Boosters are not currently part of the definition of fully vaccinated. So as it stands right now, an employee doesn't have to have a booster to be considered fully vaccinated. There is no exception for natural immunity. So if you have an employee that had COVID-19 and has antibodies, for example, that it doesn't matter under the ETS, that person would still be subject to the vaccine or testing requirement. So as Ryan mentioned, under the ETS currently, the written policy needs to be in place by December 6th, and then it needs to be ready to be implemented by January 4th. Those dates, given the limbo of the ETS and the litigation there, are likely to be pushed, as Ryan said. How far will they be pushed back? We don't really know at this point. So it's a good, like Ryan said, probably a good business practice to be familiar with the ETS and be ready to quickly put into place a written policy if the ETS survived the legal challenges. Your company needs to make the policy readily accessible to all your employees through the normal ways you typically communicate with your employees. And then the policy needs to be drafted in easily understandable language. Let's move to the next slide and talk about the first option for policy. So a mandatory vaccination policy. If you have a mandatory vaccination policy, obviously you want it to be comprehensive and effective. And we'll talk about each of these bullet points in more detail, but this is an idea of things that you want to make sure you include in your mandatory vaccination policy if you take that approach. So first, obviously you're going to include that you're requiring full vaccination, and you should define fully vaccinated, which is, we just talked about that definition, which you would want to include. You would need to make sure to include exemptions for certain medical reasons, and that would include if the vaccine is medically contraindicated, which just means a healthcare provider has determined for this person in these specific circumstances that a vaccine is not appropriate, or if there's some medical necessity that requires a delay in vaccine as well. You would also need to include exemptions for employees who are entitled to reasonable accommodations under civil rights law, and that could be because of a disability or a sincerely held religious belief or pregnancy. When you get the slide deck afterward, you can click the link there where it says reasonable accommodation, and it will take you to the EEOC's website, which gives a lot of guidance on how employers should be evaluating an employee's request for a reasonable accommodation. But let's assume that an employee is entitled to a reasonable accommodation. What does that look like in the context of a vaccine requirement? So first, it could mean that the employer allows the employee to work remotely if possible. That would be maybe the easiest reasonable accommodation to someone who's entitled to one here. Or it can mean that the employer sets up a workstation where the employee is socially distanced from other workers, or you allow the employee to work a modified shift, or you provide for COVID-19 testing. So those are just some examples of how you could provide a reasonable accommodation to an employee that's entitled to it. In your policy, you would also want to include information on how you're going to determine vaccination status, how you're going to collect and store that information. You need to include the policy for paid time and sick leave for vaccination purposes, which we'll talk about in more detail. You need to make sure to include what the disciplinary action is for employees who violate the policy. And even if you have a mandatory vaccination policy, it may be that you have some employees that aren't vaccinated because, for example, they're entitled to a reasonable accommodation or a medical exception to the vaccination requirement. So those employees would still be subject to the ETS's testing requirement and face covering requirement. So even if you have a mandatory vaccination policy in place, in that policy, you're going to want to include the policies for testing and face coverings as well for those employees that are entitled to an exception to your vaccine requirement. You're going to want to include the procedure for employees to notify the company of a positive COVID-19 test and the parameters for removal and return to the workplace, which Adrian will talk about in more detail. And then you're going to want to be really clear on who the policy applies to. And we've gotten a lot of questions about this in terms of remote workers. So the short answer is if there's, and Marie touched on this, but if you have an employee who works exclusively from home, then the vaccine and testing mandate does not apply to that worker. But the definition of remote worker is pretty narrow. So if the employee comes into the office one day a month, they would be subject to the requirement. Or if they're fully remote, but they meet with a customer or a client, the ETS would apply. Or if they're fully remote, but they attend a monthly work gathering for employees offsite or something like that, then the ETS would apply, and then they would be subject to the testing or vaccine mandate there. And then finally, you're going to want to include procedures, be very clear about the procedures for the employees to comply with the policy. All right, let's move on and talk about leave requirements. So I want to be clear up front that this is specifically with respect to vaccination as opposed to testing. So we're going to talk about the leave requirements for vaccination right now. So an employer is required to first provide a reasonable amount of time to each employee during work hours for each of their primary vaccination doses, including up to 4 hours of paid time, which includes travel time, at the employee's regular rate of pay. And then two, the employer has to provide reasonable time and paid sick leave to recover from vaccination side effects for each dose. So there are some differences between these two points here. So the first one is with respect to the employee actually going and getting the vaccine. The second one is with respect to the employee recovering from the vaccine. So for the first, an employer cannot require an employee to use personal time or vacation or sick leave time to get vaccinated that the employee has already accrued. So the paid time off for going and getting the vaccine can't cut into any of the separate leave time that the employee has already accrued. That's not the case for the second point here. So employers can require an employee to use paid sick leave that the employee has already accrued to recover from the side effects of vaccination. If an employee has not accrued enough paid sick leave for recovery time, the employer cannot require the employee to borrow from future sick leave. So in that case, the employer would have to provide additional sick leave time for recovery purposes. If an employee chooses to get vaccinated outside of work hours, the employer is not required to give paid time for that, but you'd still have to provide the paid sick leave for the reasonable time to recover. So what is a reasonable time to recover? Unfortunately, the ETS doesn't define that, but we do have some guidance on that. So one thing OSHA has said is that an employer can set a cap on the time that they provide for recovery time. And it says, OSHA says that recovery time has to be reasonable, and that OSHA will presume that if an employer makes up to 2 days of paid sick leave per primary vaccination dose, then the employer is going to be in compliance with the reasonable time requirement. So you have a safe harbor there. If you provide up to 2 days of paid sick leave, you're going to be in compliance with that, with the time you have to give for recovery. Even if an employer doesn't have a vaccine mandate and you allow for testing, you still have to comply with these leave requirements for employees that choose to be vaccinated. Okay, and we'll move on to the second policy option here, which is you will allow for testing. So one quick note on payment for testing. The ETS does not require the employer to pay for testing, but the new Utah law does. And so this is that unfortunate uncertainty that Marie was talking about. So while the status of the ETS is up in the air, Utah employers are going to need to pay for COVID testing if testing is a requirement for the employee to come to work. But we're going to talk about the testing option under the ETS now. So if an employer does not require vaccination, it has to ensure that employees who are not fully vaccinated comply with the following. So for employees who come to work at least once a week, essentially, to a workplace where other people are present, that employee has to be tested once every 7 days and has to provide documentation of the result to the employer within 7 days of providing the previous test result. For employees who don't come into the office every week, they are going to be required to be tested within 7 days of coming into the office, and then they have to provide proof of that documentation to the employer upon return to the office. So these requirements apply to workers who are coming to an office or a workplace where other people are present. And that is a pretty broad definition. So it could mean even one coworker or a customer, or even a member of a cleaning crew, for example. So it's pretty broad, right? A workplace where other people are present. All right, so an employer, and Adrian's going to talk more about this, but the employer has to maintain proof of the test result. If an employee doesn't provide documentation of a test result, the employee can't return to the workplace until the test result is provided. And here's the point we already talked about, that under the ETS, the employer doesn't have to pay for testing, but it can, unless it's required by other laws, regulations, or collective bargaining agreement. And so in Utah, it does appear that under the new law that the employer would be required to pay for testing. Employees that are not fully vaccinated are going to be subject to the testing requirements for as long as the ETS is in place. So that's an important thing to note. Let's move to the next slide and talk about proof of vaccination. Whichever option a company chooses, whether you have a mandatory vaccination or you allow for testing, the employer is going to have to know the vaccination status of its workforce. So what are acceptable forms of proof of vaccination status under the ETS? One, the shot record from the healthcare provider or pharmacy, a copy of the CDC vaccine card, a copy of medical records that otherwise show the vaccination status, a copy of shot records from public health, state, or tribal immunization information system, or a copy, is sort of a catch-all, a copy of any other official documentation that shows the type of vaccine administered, the date it was administered, the name of the healthcare provider or clinic that administered the vaccine. So under the ETS, it's not just an option for the employee to show proof of vaccine. The employer actually has to maintain record of vaccination status, and Adrian will address that. And again, this differs from the Utah, the new Utah legislation. For companies that have already been collecting vaccination status through another form of attestation or proof and have retained records of that, you don't have to re-ascertain vaccination status through one of these appropriate forms listed here, so long as the employee's fully vaccinated status was ascertained prior to the effective date of the vaccination requirement. And then finally, on this point, we have gotten a lot of questions from people wondering about employer liability here. So is an employer going to be potentially liable if an employee submits a fake proof of vaccination? So there's no requirement under the ETS that employers monitor or detect fraud. So an employer is really only going to be liable in really limited circumstances. And that would be if the employer knowingly accepts fraudulent proof of vaccination and then maintains that fraudulent proof as proof of compliance with the ETS. So very limited circumstances where an employer is going to face any liability here. Okay, and then moving on. So what if an employee can't provide one of those forms of proof of vaccination status? The ETS does have a very limited option to self-attest. So if an employee can't obtain appropriate documentation, they can sign and date a statement that attests to each of the following things here. So vaccination status, whether it's full or partial, they need to state that they lost or were unable to produce proof of vaccination, the type of vaccine administered, the dates of administration, and then the name of the provider or clinic that administered the vaccine. And then finally, they have to include a declaration that the statement is true and accurate, and they have to acknowledge that knowingly providing false information can subject them to criminal penalties. And before self-attesting, an employee has to make an honest effort to get acceptable documentation. They have to state that. And then if the employee does not provide one of the acceptable forms of proof of vaccination status, the company is going to need to treat the employee as not fully vaccinated. So I know we're giving you tons of information here, but hopefully it's all helpful, and I think it's all important. And I'm going to turn the time over to Adrienne to talk about additional requirements under the ETS.
Yeah, so I'm going to wrap it up with some of the additional requirements that companies are subject to under the ETS. Obviously, the big ticket one is how the company approaches vaccines, but there are also some requirements about what to do if there's a positive COVID test in the workplace, face covering requirements, and then record keeping and reporting requirements. So if a company has a positive COVID-19 test, so an employee is diagnosed with COVID-19 or receives a positive test, that employee must be required to notify the company promptly that they've received that result, and that the company has to immediately remove that employee from the workplace until the employee meets certain requirements. And so the employee has 3 options on how to meet those requirements to return back to work. The first is that the employee meets the requirements of the CDC's isolation guidance, which is typically a 10-day isolation period. The second option, allowing employees to return to work, is that they receive a recommendation to return to work from a licensed healthcare provider. And the third option is that the employee receives a negative result on a COVID-19 nucleic acid amplification test, or NAAT test, following a positive result on a COVID-19 antigen test. And this third option is unique. So the CDC considers NAATs kind of the gold standard for detecting COVID-19, since they're more sensitive than antigen tests. So this third option is meant for employees who think they might have received a false positive. So if they think they've received a false positive on an antigen test, they can get that double checked by an NAAT. And if that comes back negative, the employee would be allowed to remain in the workplace. One quick thing to note on this requirement is that the ETS differs on what the CDC requires. So the ETS only addresses employees who receive a positive COVID-19 test or are diagnosed with COVID-19. But the CDC says if you're exposed to COVID-19 because you're unvaccinated and in close contact with someone who has COVID-19, you should also quarantine for a 10-day period or 7 days if you're tested for COVID-19. So it's important to note that ETS only addresses employees who are diagnosed with COVID and not employees who are in close contact with somebody who is diagnosed with COVID-19. And also the ETS does not require companies provide pay to those employees who are removed from the workplace because of a COVID-19 diagnosis. The second requirement is that there are face covering obligations for employees who are unvaccinated. So employees who are unvaccinated must wear a face covering in the workplace, except for limited exceptions, such as when the employee is alone in a room while eating or drinking. They're standard exceptions that we've seen from the CDC before. So the employer has to ensure that the face covering is worn, covering the employee's nose and mouth, and that it's replaced if it's damaged or soiled. Additionally, employers cannot prevent employees from wearing a face covering, even if they're not required to do so. And that applies to customers and visitors in the workplace as well. So employers must require unvaccinated employees to wear face masks, but should allow anybody to wear a face mask should they choose to do so. And companies are not required to provide or pay for the cost of face masks for employees. This next slide will give you the definition of face covering that we've seen in the ETS, but it's very similar to other definitions, so we won't go over it in detail, but you can have it for reference in the slides. So there are also reporting requirements for employers based on if there is a work-related COVID-19 fatality or a work-related COVID-19 inpatient hospitalization. So companies have to report those work-related incidents within 8 hours of learning of a fatality or within 24 hours of learning of an inpatient hospitalization. And those have to be reported to OSHA. Also, one of the most unexpected and significant for companies requirements in the ETS is that companies have to provide certain information to employees if they're requested from the employee to provide it. So by the end of the next business day, employers have to provide an employee's proof of vaccination, which would conflict with Utah's law that does not allow employers to collect proof of vaccination. So that one is, if the ETS is implemented, would be preempted by the ETS, but right now would kind of be a moot requirement because companies should not have any documentation of employees' vaccination. But employees can request a copy of their testing that's provided to the company. And this requirement comes from if companies provide on-site testing or in situations where the test result goes directly to the employer, this allows employees to request that information so that they have it as well. And then I think one of the most significant requirements of the ETS for companies is that employees or the employee's authorized representative can request the aggregate number of fully vaccinated people at the workplace and the total number of people at the workplace. And the company has to provide this within the next business day. So that means a company needs to know and have readily available the number of vaccinated people in each of its company's workplaces, if there are multiple, as well as the total number of people in that workplace. So this is something that companies can't just note once and then store away. They need to really have access to this information and be able to readily provide it to employees or employees' authorized representatives. Additionally, OSHA can request this information, but OSHA has indicated they allow employees to request it because really the only check on a company's COVID vaccine policy is OSHA. And so they want to give some of that power to employees to ensure that a company's vaccine policy is effective and ensure that it's working well, and then report any concerns to OSHA. And then additionally, companies have to report certain information to OSHA within 4 hours. 4 business hours, OSHA can request a copy of the company's written vaccine policy or that same aggregate number of vaccinated people in the workplace, and the company has 4 business hours to provide it. So they really need to have this information readily available and accessible to provide to employees or to OSHA. So the last requirement, well, one of the last ones, is that the companies have to provide certain information to employees. And this kind of information would all be within a written COVID-19 prevention plan, which is something Ryan indicated. We created a tool to help companies comply with the ETS so that they have all of this information that they have to provide to employees in one place. Because there are a lot of requirements in the ETS, such as companies have to provide employees information about the effectiveness of COVID-19 vaccines and provide a certain CDC document to employees verifying that information. And so a lot of those requirements are complicated for companies to comply with. So that's why we put them all in one place. So a company plan can communicate all of the requirements of the ETS, like what paid time off the company is providing, how the company is requesting and storing records, what are the face covering policies, et cetera. And lastly, there are some certain record keeping requirements in the ETS. Employers, according to the ETS, have to keep a record of employees' vaccine status. As we know, the Utah law differs on that point and says companies cannot retain proof of employees' vaccine status. So that's an open issue of how that will be resolved. And companies also have to retain proof of every COVID-19 test. So companies have to keep this information as confidential medical records and keep it separate from an employee's personnel file. And so far, they're required to keep it as long as the ETS is in effect. So that's something companies need to keep in mind of how are they going to store that sensitive and confidential information. So those are some of the other requirements of the ETS. There's a lot in there, so we can't cover all of them, but we wanted to point out some of the big ones that we've seen.
Thank you so much, Adrienne. We have covered a lot of ground today. We have also answered a ton of questions in the chat and the Q&A. If people have other questions, they're welcome to put them in there, but I'll kick it back to Scott.
Yeah, perfect. I mean, this is a kind of a daunting challenge that we're faced with. The timing is critical, and would just ask if you guys would continue to keep the chamber staff apprised as this further develops. If there are court actions that would, modify what kind of approach has been recommended today, that would be really helpful. We are at 11 o'clock, which was our scheduled end time. Would really like to thank 650 Technologies for the great information and overview today. And just as a reminder, today's webinar has been sponsored by the Salt Lake Chamber's Roadmap to Recovery and Prosperity Coalition, and it will be available later today on the Chamber website. For those of you that do have questions that were maybe unanswered in the chat, you're welcome to stay on for a few minutes, and hopefully those of you from 650 can stay on as well and answer those questions. And otherwise, we'll go ahead and wrap up the formal part of the webinar. So thank you for the great information, and all of our guests, thank you for joining us. Take care and stay safe.